Well, hello and welcome to our webinar on Are You Ready for Brexit? I never thought I'd say this, but there's an almost comforting familiarity about returning to the subject of Brexit after the past 6 months of dealing with the fallout from COVID-19. But clearly Brexit issues are back on the front pages with a vengeance, and judging by the number of inquiries we're now getting, it's a subject that's very much back at the forefront of our clients' minds too. So clearly now's the time, if you haven't done so already, to dust off those Brexit readiness plans and think about any steps that you need to take to mitigate any adverse impacts of Brexit between now and the end of the year. And clearly also Australian international trade experts are in high demand at the moment in the UK. And so I'm delighted to say that taking time out of his busy schedule and joining us for today's webinar is Dmitry Grzybinsky. Dmitry is the founder of Explain Trade and a visiting professor at the University of Strathclyde. He was previously a diplomat and a trade negotiator at the WTO and beyond. He's regularly called upon to provide expert analysis on trade issues in the media and has also given evidence in Parliament to select committees considering the impacts of Brexit. Having myself participated in a number of sessions that Dmitry's delivered to lawyers at the firm here at Travers, I can tell you without hesitation that he's a highly informative and entertaining speaker who will not pull any punches about the issues that the UK will have to face as a result of Brexit in the coming months and beyond. In terms of the structure of today's session, Dmitry and I are going to kick off by looking at the current state of play in negotiations and what this means for your Brexit planning. We'll then be joined by two of our expert Brexit panel from Travers Smith, Jonathan Rush and Moji Oyediran, to look at the impacts on trade in services and then trade in goods respectively. Finally, we'll then look at some of the wider issues in a Q&A session where we'll be joined by some additional panelists from Travers Smith. If you do have any questions on any of the issues we're discussing, do feel free to get in touch, email these in or contact us by some other means and we'll get back to you on those as soon as we can after today's session. So let's kick off by looking at the state of play in negotiations. Dmitry, everyone listening is going to be aware of the announcement by the UK that it wishes to effectively override parts of the withdrawal agreement that it signed up to earlier in the year via the government's proposed UK internal market bill. Predictably, this has gone down extremely badly with the European Union. Where do you think this leaves us in the negotiations on the future trading relationship, and what's the risk now, would you say, of a no deal?
Thanks for having me. In a way, this changes things only a little bit. The state of play remains that the EU has signaled some willingness to move on state aid, and if Boris Johnson and the backbenchers that he needs are willing to meet them at that halfway step, then a deal is still entirely possible. There's no trade reason a deal couldn't happen, and the EU certainly didn't walk away from the negotiations despite their ire over this move. What's become less likely is even further concessions from the European Union in order to try to lure the UK to the table. Fundamentally, this question of state aid and the future UK subsidy regime is all about trust. And the kind of concessions the UK wanted were about the EU basically agreeing to trust or more greatly trust the UK and how it would behave in the future. And this move hasn't helped in that direction.
Yeah. So at this juncture, would you say that businesses should really be preparing for all eventualities, including no deal? And if so, doesn't that make the whole process even more complicated because you're effectively having to prepare for two substantially different outcomes?
Well, first I would say that for the vast majority of British businesses, if you don't happen to be in a tariff-exposed sector, no deal looks a heck of a lot like the kind of deal that the UK might get. So actually your preparations should not be that wildly divergent. You should be preparing for the things you will need to do at the end of transition, and those won't change substantively for most businesses, whether there is a deal or not. Certainly, this has made a no deal more likely, which means that if you are in a tariff-exposed sector, for example, then you do need to be preparing for both eventualities, one of which is very bad. And also, I would say that if you are in a business whose forward planning basically relied on goodwill and cooperation between the regulators in the EU and the UK, not necessarily in the form of a free trade agreement, but generally on day-to-day issues and kind of facilitation cooperation, then the higher likelihood of no deal, the significantly grimmer mood music, and the fact that the two sides are very much glaring at each other across the channel means that your contingency should reflect the fact that there's very likely not going to be quite as much sort of accommodating measures and goodwill on both sides as we would have liked to see.
Understood. So for a lot of businesses, there may not be clear daylight between a deal and no deal, but what are the sort of main areas where you think a deal would make a difference? You mentioned tariffs, obviously.
Yeah, so I mean, tariffs is overwhelmingly the largest area. It's fundamentally a deal about movement of goods, and it's about eliminating those tariffs at the border. There's also some hope that the deal will improve some levels of services market access for certain sectors. There's a slim chance, for example, UK logistics companies will have the ability to keep offering some level of service inside the EU. There's a range of sort of regulatory equivalencies that might occur. But overwhelmingly, as you said, there's just not that much daylight. What is being contemplated is a very, very slim deal indeed.
Understood. Now, we've known for some time that there isn't going to be any extension to the transition period beyond the 31st of December this year, but many commentators and businesses have called for more time to prepare. Do you think there's any chance of some kind of implementation period emerging as part of a deal that would kick off, from the start of next year?
So there are two options for what an implementation could look like. It seems incredibly unlikely that an implementation would literally kind of extend transition, but it is possible, for example, that the two sides unilaterally, not through an agreement, but on the eve of goodwill from a free trade agreement, extend a range of temporary measures to one another. So for example, they continue recognizing each other's certification marks, for example, for a period, and that kind of cobbled together out of a whole range of those kind of unilateral measures, you might get a de facto implementation period that for your business means that things stay sort of similar to the way they are now for some time. But very, very honestly, if I was a business, I would not be banking on that. The political imperatives in the UK, as I, ignorant foreigner, read them, is that it is absolutely vital that the UK feel like it can announce at the end of transition that it has taken back control of its laws and regulations, and any kind of implementation period would dilute that quote-unquote freedom. So I think the planning has to be there will be no implementation period, and you should prefer to be pleasantly surprised rather than rudely shocked.
Okay, thanks, Dimitri. So let's move on now to trade-in services, looking at the future relationship in more detail. And here we're going to be particularly looking at non-financial services. One of the things we're going to be discussing in this section is the impact on the movement of people. And so, as I mentioned at the start, we're going to be joined for this section by Moji, who is one of our immigration specialists, together with Jonathan, who I think I can kindly say is our resident Brexit nerd, who's going to be talking about what you should be doing to prepare for the 1st of January. But just turning back to you, Dimitri, can you briefly explain what the current position is on services and what will change on the 1st of January?
Sure. So the whole principle of the single market in the EU is the ability that you should be able to sell services across borders, across the entirety of the EU. That is the default position unless there is a compelling reason why you can't. In practice, what that means is we as services negotiators divide services into 4 modes, depending on who's moving. So effectively what that means is that a customer anywhere in the EU can buy a service remotely from, say, a firm in Edinburgh or London. They can travel to the UK to procure that service, and their governments back home will recognize that service as legitimate. UK firms can establish a foreign presence, so they can establish a branch or an office in another EU country and offer services through it. And of course, UK citizens and permanent residents can travel to anywhere in the EU and be paid to provide a service and then come back. After the transition period ends, most of that is going to become significantly more restricted. The European Union and its individual member states will have regulations that prevent their citizens from legitimately purchasing certain kinds of services from the UK. I mean, that hits financial services, but it hits many, many other kinds of services. Similarly, there will be some services, a very limited number, for which the EU citizens will not be able to travel to the UK, get that service, and have it be recognized. So this generally applies to things like specialized training. The ability of UK firms to establish especially branch offices that provide services in the EU will likely be significantly restricted and will have much tighter requirements. And under almost any scenario, including under a trade deal, the ability of a UK firm like yours sending an employee overseas to deliver a service into the EU will also face significant restrictions and limitations. They will not be able to legitimately apply for a visa of the type that allows them to work overseas, depending on their industry and what the kind of work they want to do now.
Okay, thanks. So let's pick up on some of those points and take a practical example. Let's say you're a tech business, UK based with customers in the EU. You provide most of those services remotely using servers and staff based in the UK, but sometimes, as you mentioned, Dimitri, you need to send staff to work at a customer's site in the EU. That might be to help their IT team with implementation or provide training to their staff. And let's also assume that any data exchange with the EU doesn't include personal data for these purposes, because we're going to come back to that topic a bit later in the session. What sort of practically do you think would change for that kind of a business after the 1st of January?
Okay, so for the core business, as in selling, say web design to an EU firm, setting aside this question of data and privacy, which is a whole nother thorny barrel, perhaps on that, not so much. EU citizens will still be able to log on to a UK website and get their website done. That won't be a problem. The firm will likely struggle or not be able to, say, establish say it's got lots and lots of business. It will struggle to establish a branch in, say, Belgium, where people can walk in and chat to web designers. It will struggle to do that. It will need to have a local partner. But probably the biggest barrier will be when they try to put someone on a plane from the UK to the EU to supply those services. Depending on whether there's a deal or not, they may either be completely unable to do that legitimately, or they will face restrictions such as only being able to do so for a certain number of days in any given year, only under certain conditions. It might vary member state to member state because, of course, immigration is handled at the member state level within the EU 27. And they will generally just have to jump through a lot more hoops and have far less certainty. Even if the visa class is there, and even if they are entitled to it, what it'll likely mean is that every time they want to send someone, they have to apply for one of these visas. And then they have to wait as it's processed, perhaps pay a fee, and then wait to get it back. That significantly increases the uncertainty and probably the costs, as well as the responsiveness. You can't just throw somebody on a plane with 2 hours notice if your website or your web server in another country is suddenly struggling.
Absolutely. So clearly from what Dimitri's saying, there would be issues with staff travelling to the EU for work purposes for a business like that. Moji, if I could bring you in here, in practical terms, what do you think this business is going to have to do that's different from what it does at the moment?
Yeah, thanks. At the moment, obviously, free movement rules have meant that a UK national just needs to pitch up at the airport with their passport, and no questions need to be asked at the border around what they're doing or how long they'll be in the EU. Obviously, from the 1st of January, once we UK nationals become considered as a third country, and will have to meet, as Dimitri said, the requirements, the local requirements of the EU 27 member state they're travelling to, there will need to be consideration by businesses of the purpose of the trip when they're sending people over to the EU. And there may well be extra steps they need to take before the individual can actually jump on the plane. Now, it's the activity rather than the duration of time being spent that is key. So it doesn't matter whether it's a 1 day or 6 month visit for business. It does need to be an activity that meets the scope of the permitted activities within the EU member states business visitor requirements. So typically meetings with colleagues would be fine, meetings with clients, for example, to take specifications of a particular project where the business then takes the work away to perform in the UK would also generally be fine. However, when it comes to project implementation or consulting activities, they would generally stray into the territory where a work visa is required. Now, that can involve providing lots of information about the business, including how it's established, the work it does, both in the UK, and the work it intends to do with clients in the EU, and also providing quite detailed information about the individual who needs to apply for a visa. And there will obviously be costs involved and timing implications for that. So it's a good idea for businesses to start to think about what types of activities they actually send individuals to the EU 27 to do at the moment, and scope out whether those fit into existing rules, and work out perhaps a plan as to whether additional steps need to be taken now to start to think about planning for visa requirements.
Okay, thanks, Moji. Dimitri, so let's say in the light of what you and Moji are saying, that the business has just decided it's just too difficult for the time being to continue sending staff to the EU. Given particularly the experience of the last 6 months, would there be anything to stop that business providing these services remotely via Zoom or another platform?
In most cases, there likely wouldn't be, but I mean, you're always dealing with the restrictions of online delivery and not being able to be physically in the room. I'm currently procuring some web development from a firm in another country, and my inability to walk over to their offices and physically strangle them has been a real restriction on our process. But kind of more seriously, there are certainly restrictions. To give a really practical example, I'm a consultant and a trainer. When I moved to online delivery like this, I effectively lost the ability to deliver the 3 to 4 hour training courses that I used to do, because web delivery really doesn't allow for that. I had to switch down to a 1 hour delivery. If there were no restrictions like that and I could do it in person, I would effectively be able to charge 3 to 4 times more and deliver a much more comprehensive package. When you are competing against a local firm, the fact that they can say, we can have somebody physically in your office in 2 hours is an advantage for them. The fact that they can negotiate the contract sitting eye to eye is an advantage. The fact that they have that personal touch will all be an advantage. And that'll only grow starker once, God willing, this pandemic is over and we don't all face the restrictions we currently do on face-to-face contacts.
Yeah. Moji, anything to...
Yeah, just to chip in there, one other way that a business might be able to get around and actually compete effectively, as Dimitri said, in relation to given the restrictions, would be thinking about whether they have EU citizens who are in their existing workforce who might be able to go locally to travel to the EU to actually provide the services. Now, obviously, EU citizens continue to have free movement within the EU. It's only the sort of the UK passport holders that lose that right. So that may well be a workaround to allow a business to continue to compete post-transition. But clearly, one thing to sort of, as a word of warning, is really around the recruitment implications and potential discriminatory implications of essentially recruiting an individual based on nationality or refusing to recruit an individual based on their nationality. So you don't want to advertise and say you only want an EU national for certain roles because you anticipate you will want to send people abroad, but you certainly can use your existing staff to put you in a better position, obviously given the new world that we'll be entering from next year.
Thanks, Moji. So let's just turn to the broader picture, and Jonathan, I want to bring you in here. Can you just set out what services businesses with trading partners in the EU will be doing to prepare for the 1st of January?
Yes, thanks, Ben. The first thing to check, and we can help you with this if you don't already know the answer, is what commitments the EU has made, either under the WTO services regime or any EU-UK FTA, if we get one. Now, the reason that we'd look at that first is that if the EU has committed to allow a certain level of access, then you should be able to take a moderate level of comfort from that, because in principle, member states should have adjusted their national laws so as to permit services of that type to be provided by non-EU firms. But if there's no commitment, or it's subject to conditions or reservations, then unless the sector you work in is subject to a harmonised set of rules across the EU, and relatively few services sectors have been sort of harmonised in that sort of relatively ambitious way, then what you are allowed to do will be governed by the national rules in each of the EU member states in which you've got customers. So the key thing you need to find out is whether businesses from outside the EU are treated differently from EU businesses. We can help you with that by involving firms that we regularly work with in different EU member states, but I'm afraid there isn't likely to be a one-size-fits-all answer for the whole of the EU.
Understood. And what sort of differences in treatment should businesses be looking out for then?
Well, as Dimitri mentioned, for more highly regulated services like transport or audiovisual, it's really a similar issue to financial services. Non-EU businesses are simply not authorised to carry out the same range of activities that EU businesses are. In other sectors where there's a requirement for authorisation, you may find that in principle you can carry on much as before, but you're made to jump through more administrative hoops before you can get that all-important permission to operate. And then some countries may also impose establishment requirements. So whereas they're prepared to allow other EU providers not to have a commercial presence in their territory, they may continue to insist on it for non-EU providers. And then in some cases, you may be able to carry on providing services, but only if you comply with more onerous conditions. So an example of that might be insurance requirements, where member states may be happy for EU providers to rely on insurance cover obtained in their home member state, but then they may insist that non-EU firms obtain separate insurance cover locally. Now, that's not an exhaustive list, but hopefully it gives you a flavour of the kind of differences in treatment that you could be looking at.
Okay, so let's say there is a difference in treatment and it's going to be quite onerous to comply with. Are there any workarounds?
Well, it might be that you can largely preserve your existing treatment by establishing an EU incorporated entity and providing services through that vehicle. And I want to stress here that that's slightly different from what Dimitri was saying about branches. A branch will be sort of effectively linked to the UK incorporated entity, whereas here an EU subsidiary, that would be a sort of separate EU legal person. And as a result of being an EU legal person, it should therefore be treated in the same way as before, even though it will be owned by a non-EU business. And this is effectively what many financial services have done. There's a slight caveat in that you'd only be able to do that in sectors where, again, as Dimitri says, the member state in question permits what's called Mode 3 access, which is the right for non-EU service providers to establish themselves in the EU. But countries will reasonably often permit that type of access because obviously it does encourage inward investment by non-EU businesses. Having said all that, though, it's not a step to be taken lightly. For example, you need to think very carefully about the tax position, and in most cases you'll need a genuine presence on the ground, so we're not just talking about a brass plate operation here. And then going back to the issue of people that you've been talking about with Moji, if you want to second staff from the UK who are UK citizens, then there's likely to be additional red tape of the type that Moji's already outlined. And if your main issue is that you need to send UK-based staff to work for customers in the EU on a temporary basis, it doesn't really help because that problem, as Moji's explained, is more to do with citizenship than the location of the supplier.
Okay, thanks, Jonathan. So before we move on to goods, I want to just turn to UK businesses providing services within the UK. Large number of UK businesses have obviously historically relied heavily on EEA citizens for their recruitment, ranging from hospitality and leisure through to tech businesses, which need skilled programmers and so on. Moji, what does the UK's proposed new immigration system mean for those businesses?
Yeah, so it's quite a big change actually for new hires, for businesses who are hiring EU nationals after the new immigration system comes into place. Essentially, it will mean that EU nationals will be treated in an equivalent way under the same immigration rules as existing non-EU nationals are treated. That means it's quite a rigid system for visas, and right to work and work visas will be required generally across the board. So under the new system, there will be a skills threshold that will apply, and essentially for employers who want to sponsor work visas for both EU or non-EU nationals, they will need to hold what's called an immigration sponsor license. Now, that is an administrative step that businesses, we're actually helping lots of businesses apply for sponsor licenses at the moment, where they haven't yet currently needed to use that because their focus has been recruiting from the EU. Actually, from next year, they will also need a license in order to recruit EU nationals. The thing to remember about the new system and the new regime is that it will be quite inflexible in terms of requiring certain thresholds to be met, and one of those is around skill level. So certain jobs the government has decided meet a skill threshold and can be sponsored, whereas other jobs, so for example, hospitality jobs mainly do not generally meet the threshold, both in terms of the skill level and also the other element of the new requirements that will be problematic for lots of employers, the salary threshold that also applies for skilled roles. So it is going to involve a lot more administrative steps to be able to get EU staff recruited, and it won't be as under the same ease as we currently have under the current system.
Thanks, Moji. And where a business already has a significant number of EEA citizens on its staff, which it wants to keep if it can. What should it be doing ahead of the 1st of Jan?
So the position for existing EU staff is actually quite good. They are protected under the EU withdrawal agreement. And what that means is that they will be able to continue living and working in the EU, in the UK beyond the end of the transition period. They will need to apply though for status under the new EU withdrawal agreement that's been introduced in the UK. Now, lots of employers have been encouraging their EU staff to apply now, or at least sooner than later. Even though the system is open, the deadline isn't until the end of June next year. But clearly, as we get closer to the end of transition and the deadline, we expect application numbers to increase, and also for processing times to get longer. So it's about getting the information out for most employees at the moment, to let them know that they need to make their applications and they need to do so before the deadline. Now, one thing that I just think it's worth flagging for businesses employing EU nationals is that whilst there is this requirement to apply, the deadline, as I said, isn't until the end of June next year. And at the moment, EU nationals already in the UK, or anyone who arrives before the transition period ends, will actually still be covered and be able to continue relying on their passports, their EU passports, or their EU ID card as evidence of right to work. This means that employers need to be careful not to insist on having the EU ID cards, EU settlement scheme application processes being in place before an individual is recruited or comes on board.
Okay, thanks, Moji. So let's move on to goods. And I suppose it's worth making the overarching point here that although the UK economy is obviously dominated by services, many of those services like retail, hospitality and leisure rely on goods as a key input. So it's important not to underestimate the importance of goods trade for the wider economy. Dimitri, I want to just start by looking at the position on goods if there's no deal. In that case, it's clear that tariffs are going to be payable on the EU to UK goods trade. What do you think the impact of those might be?
Depends strongly on the sector. The EU's tariffs tend to be generally very low, except where they are incredibly not. So if you are in a tariff-exposed sector, those generally are concentrated in agriculture, with a little bit in manufacturing and places like autos. What that effectively means is that overnight, your products become either significantly or completely less competitive in the European Union and for European Union buyers. I think in the majority of cases, that would mean that your traditional customers would shift away from a UK supplier and towards procuring it elsewhere, unless it was genuinely something that they could only acquire from the United Kingdom, at which point they would pay the tariff, I suppose, while frantically looking for another option so that they wouldn't have to. If you are in a less tariff-exposed sector, then the issue for you is overwhelmingly around paperwork and compliance at the border. The way that you deliver your goods into Europe may no longer be viable. What I mean by that is that within the customs union and single market, the ease of moving things across borders allowed cross-border movements. For example, a truck with 800 different products on it, completely different product types, to say restock a supermarket, that are simply not viable anywhere else in the world, because each of those products would otherwise need to be declared for the purposes of customs, valued, perhaps weighted, in order to determine what would be the payable tariff, if any. That will no longer be viable after the end of transition. So it's possible that even if you are not exposed to tariffs, the way that you do business by the very fact that tariffs now apply anywhere will mean that you have to fundamentally change the way that you supply your customers, or perhaps the way that your suppliers supply you.
Understood. And just picking up on that issue of non-tariff barriers and customs paperwork and so on, if we do get a deal, will that significantly help on that front as well as on the tariff front?
Likely not. To begin right at the start, if we are talking about the issue of tariffs and sort of customs declarations, then even if a deal eliminates all tariffs, actually taking advantage of that elimination requires additional paperwork because you have to prove that your good was sufficiently made in the United Kingdom to qualify for the lower tariff. Basically prove you are not trans-shipping goods into the EU to take advantage of the free trade agreement. So that would make it more difficult. There is a hope that if there is a deal, this positive mood music I talked about in an earlier segment would mean greater customs cooperation. There's a whole range of things that the customs authorities can work towards and do in terms of information sharing, in terms of intelligence targeted checks and so on, that will over time make life easier for businesses doing sending things across borders by just basically facilitating the process. But that requires firstly goodwill, secondly it takes time, and thirdly I would caution that even on borders that between countries that have outstanding cooperation and huge amount of trust, like say the borders between Sweden and Norway, or Switzerland and any of its EU 27 neighbors, there are still sometimes hour-long delays for trucks, and compliance is still a costly and time-consuming procedure.
Okay. Jonathan, we've recently had more detail from the government on its border operating model and proposals for a phased introduction of customs requirements. What are the key points that businesses need to be aware of in relation to those proposals?
Well, I think the first point to note is that the phasing in of customs requirements is only for imports. If you're exporting, you'll need to be able to comply with EU customs requirements in full from 1st of January. But going back to imports, the full regime is not expected to apply until July next year. So on 1st of January, the majority of goods, with the exception of live animals and plants deemed to be in what's called a high risk category, the majority of goods will be able to enter the UK without the upfront paperwork that you currently need if you're importing goods from, say, outside the EU. So instead, importers will be permitted to provide customs declarations in arrears, and if tariffs are payable, they could also be paid in arrears. So that would be in the no deal scenario. Import VAT will also be payable, but it's expected that most VAT registered traders will be able to use postponed accounting to avoid having to pay that up front. The next key date after 1st of January is 1st of April. That's when all products of animal origin and all regulated plants and plant products will need to have upfront paperwork. So basically what we're talking about there is food, and that paperwork will include relevant health documentation. To the extent that those products need physical checks, those are going to be carried out away from the border to try and reduce the risk of congestion. So for most goods, importers have got a little bit of extra time in which to prepare, but that doesn't mean you can sit on your hands between now and 1st of January. For example, importers will still need to provide a lot more information to HMRC on what they've imported. So for instance, they'll need to know the correct commodity code for all the goods that they import. And as Dimitri's explained, these requirements are coming in even if there is a deal, and they will take time to prepare for.
And will these measures be enough, do you think, to avoid delays at the channel ports in particular?
Well, let me put it this way. Customs and logistics experts giving evidence to MPs earlier this month were asked about the likelihood of what was described as chaos in Kent. And the most optimistic of them thought that the chances of disruption were at least 50%, and the other two put it at much higher at 70 to 80%. So right now it isn't looking great, and even if January goes more smoothly than expected, the real test could be in April, or more likely July, when everyone will be expected to comply with full upfront customs requirements for imports from the EU.
Okay. And what if you don't import anything directly yourself? You just buy from wholesalers?
Well, then you, on the face of it, your position there looks sort of slightly easier, because those wholesalers or their UK suppliers will be the importers. So they're the ones that have got to deal with all this extra red tape. Now, it may be tempting to accept your wholesaler's assurance that they've got it all under control, but I really would encourage businesses in that position to ask quite searching questions of their suppliers on this. In particular, I'd want to understand what those suppliers are doing to prepare and what contingency plans they've got to deal with the kind of disruption we've just been talking about. I'd also want to understand what their supply chain looks like. For example, does it rely heavily on SMEs, which are generally thought to be less well prepared for Brexit than large corporates? And are there EU suppliers geared up to provide all the extra information that's needed for customs declarations, because those EU suppliers may not be used to providing all that? Also, the issues aren't confined to goods originating in the EU either. So let's say your wholesaler is supplying you with goods from the rest of the world that are coming into, say, Rotterdam, and then get distributed to the UK via trucks arriving at Channel ports. If so, then those rest of the world goods may be vulnerable to delays in the same way as goods originating in the EU. And in a no-deal Brexit, you could also end up paying two lots of tariffs on them, once on entry to the EU and then again when they arrive in the UK. So if you haven't asked those kinds of questions of your suppliers, then you've no idea whether you actually need to develop your own contingency plans in case your existing wholesaler can't actually supply you.
And what might those contingency plans be? Are we just talking about stockpiling?
Well, stockpiling is the most obvious one. We know that a lot of businesses are doing that, but there are a number of other options you could consider. So, for example, it's worth thinking about contractual steps you could take, such as priority supply obligations. The idea there being that you don't find yourself at the bottom of the pecking order if there's a shortage. Now, you might have to commit to paying a higher price to get those, but you should aim to structure the arrangement so that you only pay if you need to call upon it. So it's really more in the nature of a kind of option. There may also be the scope for sort of mutually beneficial deals of this type with UK suppliers, which currently export most of their production to the EU, because if they can't reach their customers in the EU because of delays at Channel ports, they may be very happy to have the option to sell to you instead. And again, you may be able to structure those kinds of arrangements so that you only pay if you actually need to call upon it. And then you may also want to explore whether you or your suppliers should just try and avoid the Channel ports altogether, for example, by using short sea shipping to bring goods into the UK on containers. Now, the advantage of that is that you would be using ports which are already set up for full customs processes, and they're used to dealing with those, whereas that's not true of the Channel ports. And therefore, as a result, they'd be less likely to be affected by delays. But just going back to stockpiling that we started with, I think one point to think about there is that storage space is likely to be at a premium because of the run up to Christmas. So it may be worth being a bit creative with your existing premises. For example, possibly looking at using non-warehouse space for storage, or exploring whether you could make use of shipping containers on a temporary basis. But do make sure you talk to landlords about that and consider whether it has any implications for you for planning or for your insurance. There's an excellent briefing on our website from our real estate team if you want more detail on those issues.
Well, thank you all very much indeed for your insights there. And I'd like to move on now to the Q&A section of the webinar, which will allow me to bring in some of our other panel members who I will introduce as we go along. We'll do our best to get through as many questions as we can in the time that's left. If we've been unable to answer yours, you'll find there is a facility for you to submit questions just under the video, or alternatively, just email it to me at ben.chivers@traverssmith.com, and we'll get back to you as soon as we can. Right, so let's start with data protection, and I'm going to turn now to my partner James Longster, who specialises in technology and data protection matters. James, if you handle personal data relating to EU citizens, what are the data protection issues that you're going to need to address before the 1st of January next year?
Thanks, Ben. Well, as with all of the topics we're looking at, there are a number of things to check. But taking a step back, it's important to note that from the 1st of January, there will effectively be 2 versions of the GDPR, the original EU GDPR and a new UK version. So if you're a UK business, you'll be subject to the UK's own version of the GDPR, and you might also be subject to the original EU GDPR. And the way to check that will be to look at the territorial scope provisions of the GDPR in Article 3. So if your business falls within the territorial scope of the EU GDPR, then you'll need to continue complying with it. And there are some practical things you'll need to think about. Firstly, if you don't have any physical operations in the EU, then you'll likely need to appoint a third party in the EU as your authorised representative to deal with regulators and data subjects in respect of your EU GDPR compliance. It's also worth mentioning that this will very likely apply in reverse too. So EU businesses that don't have any physical operations in the UK may need to appoint an authorised representative in the UK to comply with UK GDPR. If you're a business that does have operations across the EU, then you might want to also consider who your lead supervisory authority is. So that's the regulator who you theoretically deal with for pan-European EU GDPR issues. And this will be particularly important if your lead supervisory authority was the UK's ICO, as for obvious reasons, the ICO will no longer be able to be a pan-European lead supervisory authority. The other big topic that needs to be considered is cross-border data transfers, as without what is known as an adequacy decision from the EU in respect of the UK, additional measures will need to be put in place to safeguard transfers of personal data to the UK, such as standard contractual clauses, although their use isn't immediately straightforward at the moment in light of the Schrems II judgment. This will also apply in reverse, where additional safeguards could be required to transfers of personal data from the UK to the EU. And it's also important to remember that this applies to transfers within your corporate group, as well as to any service providers you use. Finally, businesses will need to revisit their policies, data protection impact assessments, and contracts to check whether they need to be refreshed. At the very least, they might need to be updated to reflect the fact that UK will have its own version of the GDPR that organisations will be subject to. There are also other, more substantive updates that could be required. For example, if you're a UK business which needs to appoint an authorised representative in the EU, then the details of that authorised representative must be included in relevant information notices to data subjects. Now, whilst I appreciate that businesses will have spent time, effort, and often money updating their policies to comply with GDPR, this is more than just a box-ticking exercise and needs to be looked at properly.
So I'll turn now to Doug Bryden, who heads up our risk and operational regulatory practice. Doug, for businesses that want to keep selling into the EU after the 1st of January, will producers need to appoint an authorised representative in the EU?
Yes, they probably will. It will be very dependent on what their current importation routes are, and also the nature of the products. So just taking those two points, if it's kind of one of the more regulated products, so that could be a medical device, medicinal products, or construction, or certain electronic devices which are subject to kind of enhanced regulatory controls, then an only representative will be needed where there is a non-EU manufacturer. It could well be that a UK entity already has a European body they can rely on, but if not, they will need to find that authorized representative to do it. It's very much an administrative function, actually. It doesn't really do a huge amount, but it is a kind of an EU-based entity where both regulators and consumers can go back to.
Okay, thanks, Doug. And what other product regulatory issues do businesses need to consider ahead of the 1st of January?
Well, I won't go into all the logistics and some of the tariff issues, But just from a more regulatory point of view, issues to really think about would be if it is, let's say, regulated, but not the highest regulation, so the lower regulatory products, then there will be potentially concerns around labeling. So if you currently have a CE marking on that product, which is a self-certified compliance mark, then that again may be required going forward. Coming from the UK to the EU will be relatively straightforward. People will continue to CE mark, the conformity tests will probably be the same, and the EU obviously will recognise that. Going from the EU to the UK, I think in the short term, it's been confirmed that the UK authorities will accept current CE markings. However, from 1 January 2022, the UK are going to require an additional mark, which will be a UK-specific mark, which will be UKCA. So that will have to be transitioned, but we see common sense will prevail on those markings. On the more regulated products, there will also be things to think about where you have to do some conformity testing by third parties. So here, these are the more kind of controlled products where there needs to be an independent assessment and notified body appointed to do the certifications. That will be coming an issue for a lot of importers. The EU have clearly stated that they're not going to recognise certifications issued by the UK certified notified bodies from the 1st of January. So a lot of work needs to be done to get new notified bodies appointed and certifications in place, and that's something which should be happening apace at the moment.
Thanks, Doug. And let's just move on to tax. So here I'll bring in Russell Warren, who's one of my tax members. Russell, what are the key tax considerations that a UK business looking to set up a subsidiary in the EU to provide services would need to think about?
Well, that's a really interesting question, Ben. And I guess the way that I would start to think about answering that is to question where the business will have substance. And so rather than, I don't know, looking for a benign jurisdiction to set up in from a tax perspective in the EU, ask yourself the question, where do you have substance? Because actually to fall within tax jurisdictions and to get the benefit of reliefs and exemptions and so on, you need to be properly in that jurisdiction. So no sort of post box office, properly there, feet on the ground. And once you've got that, I guess the thing that you'll then be thinking about primarily is the rate of corporation tax that you are going to be paying in that jurisdiction. And perhaps slightly surprisingly, there are a wide range of corporation tax rates in the EU. Ireland's down at 12.5%, France is at 33%. The UK is 19%, I think in that context looks actually quite competitive. But you actually need to look beyond the headline rate. And that is because most jurisdictions run particular regimes or give special rates to particular types of businesses and or particular types of income streams, and thinking there particularly around IP and so on. And those rates and those regimes might give you a much lower effective rate of tax than the headline rate. So always look beyond the headline rate. And then I guess your next biggest cost is going to be tax in relation to your staff, if you have staff in that jurisdiction. So thinking about things like income tax and social security rates, thinking about the extent to which you will have to pay those taxes on behalf of your employees. In the UK, that's the PAYE system. And think about how easy is it to deal with the tax authorities? What is the level of admin that you're going to have to put in place to operate in those jurisdictions? And then I guess finally, in sort of the big picture, you'll want to think about how you are going to bring any profit or cash back into the UK. And there you'll be looking to the tax treaty network that jurisdiction has to ensure you can extract that cash or that profit tax efficiently. But I guess the thing is, if you've got substance in a particular jurisdiction, then tax is in a way just one small part of the considerations. You'll have regulatory rules, as Doug has just talked about. You'll need to think about the legal environment that you're operating in, and that will be as important as the tax position, if not more so.
Thanks, Russell. And let's say the main driver of the location is regulatory rules or legal environment rather than tax per se. presumably in that scenario, you're still going to have to think quite carefully about your tax position. What are the sort of key issues that businesses would need to consider?
Yeah, you're absolutely right. So tax is important. It just shouldn't be the driver. Once you've identified a location, you'll need to do the sort of admin, get your company registered for corporation tax, payroll taxes, VAT, and so on. And you'll need to find yourself a good local advisor that can help you with that and help you with your compliance. Once you've sort of got over that piece, you'll need to think quite hard about how the subsidiary in the EU will be contracting with its UK parent. And that may come in a number of forms. It might be that the UK parent is providing management or other central services to the subsidiary. There might be intra-group trading. And depending on the size of your business, you might need to consider transfer pricing rules. And those transfer pricing rules, we have them in the UK, they're pretty prevalent EU-wide. And they're really important because they can impose a different rate of consideration or different rate of interest, if we're talking about debt, between those parties than you actually have agreed to contractually. And therefore, you can get a different tax result to the result that you have contractually. So really important to think about transfer pricing. And then there's the crucial element of ensuring that any profits or any cash that has arisen in the sub, you can extract out tax efficiently back to the UK. Now, most people think of that as about paying dividends. And that is, I guess, the most obvious way to do it. And for a UK parent, that is quite tax efficient because those dividends will be received tax-free in the UK. But the subsidiary is unlikely to get a tax deduction for paying them. And so that's one thing to consider. Also, you often need retained profit, or what we call distributable reserves in the UK, to pay dividends, and you may not always have those. And so people also think about putting debt in place between the parent and the EU subsidiary, and you'll pay interest on that debt, and that is a way of moving cash out of the EU back to the UK. And here, tax treatment here in the UK, you'll be taxed on that interest receipt, but the subsidiary in the EU might get a deduction for paying that interest, although there'll be various rules that might prevent that deduction.
Okay, thanks. And you mentioned tax treaties. Why are those important?
Yeah, that's a really good question. So tax treaties are a slightly curious beast. And what they seek to do is they seek to ensure that leakage that might otherwise arise doesn't in fact arise between two jurisdictions. So what do I mean by that? Well, if you're in the EU paying interest or dividends back to the UK, your local jurisdiction in the EU might impose a withholding tax. And we have one in the UK, we have a withholding tax on interest, 20% has to be withheld. Dividends we can pay out without withholding. But without the double taxation treaty, that withholding that's paid over to the local jurisdiction will constitute a real tax cost to the parent because it can't get that tax back under domestic rules. And so it looks to the treaty to see whether or not the treaty, which is an agreement just between the two states, the UK and France, or the UK and Germany, for example, to see whether that treaty provides relief. And they usually do. And that relief is either in whole, so there's no withholding at all, or it's in part, so it reduces the domestic rate of withholding in that local jurisdiction. And these treaties are going to become even more important after the end of the year, after we are properly out of the EU and can't rely on the automatic intra-EU withholding reliefs. And that kind of brings us full circle to where I started on substance, because in order to rely on the double taxation treaties and to get the benefit of them, you need to show that you have substance in that jurisdiction.
And if I can turn back to you, Dimitri, a question about proof of origin. If there's a UK-EU trade agreement providing for zero tariffs on most goods, is that zero rating automatic, or do I have to do something positive to get that tariff treatment?
It's absolutely not automatic. What you effectively have to do is prove to the EU customs authorities that your goods have sufficiently originated in the United Kingdom. What does that mean? Every free trade agreement does this slightly differently, but generally what it looks at is you have to demonstrate what percentage of the value of your good came from the UK, or whether your good was substantially transformed in the UK. So if you have a widget that is made from Korean steel, you're probably fine because you've substantially transformed some steel into a widget. And you can demonstrate that is a completely new thing. You are fine to therefore, with the documentation that documents that process, demonstrate that you substantially transformed it. That is now a UK widget. However, if you have just repainted a Korean widget and you're trying to take advantage of the EU FTA, then not enough of that widget's value add took place in the UK, and it hasn't been substantially transformed enough. It's still fundamentally a widget. It's now just a blue widget. So it is not considered a UK widget and isn't eligible for the zero tariff rate in the EU-UK FTA as yet, hypothetically. And proving that is often by far the most onerous part of customs procedures because it requires the most documentation, especially when goods are very, very complex, involve a range of components sourced from all over the world, and those components in turn are made of components and transformations and work from all over the world or the region.
Thanks. Jonathan, is there anything you'd add to that?
Well, really just to say that, as I was mentioning earlier in relation to the information needed for customs declarations, that a key practical point for importers is that their EU suppliers may not be used to providing proof of origin or keeping the records that are required to back it up. And if they can't provide that documentation, then tariffs will be payable, and they normally fall to be paid by the importer, not the exporter. So it is worth having that discussion with EU suppliers now, even though we're not yet clear what any deal with the EU will say on preferential tariffs.
Okay, thanks, Jonathan. Let's turn to the issue of dispute settlement. Dimitri, if I'm not getting the level of access to the EU market that I think I'm entitled to, either under WTO rules or an EU-UK free trade agreement, what can I do about it?
So in both cases, there are established procedures that are there where one side can raise the issue with the other and basically keep elevating that process until it reaches a dispute settlement proceeding, which is sort of vaguely resembles a court. So the practical steps you would take is first to document everything, document what you are experiencing. Second, to take that information to DIT, to the Department of International Trade, and highlight to them the exact problem you're having and where you think the treatment you're receiving is falling short of the EU's obligations under either the WTO agreements or the EU-UK FTA. And then basically continue supporting DIT with the information that they need as they push that through escalating series of initially consultations and eventually potentially a dispute settlement process where they effectively take the EU to court to demonstrate that they're doing the wrong thing.
Okay. And I want to also just pick up on a question around EU negotiated trade agreements. What's the position with those EU negotiated trade agreements after the 1st of January next year?
So for agreements that the EU has negotiated while the UK was a partner,
Yes.
a number have already been rolled over in either in a limited form, in a complete form, or in a replacement form. So this would be the Korean agreement, the Japanese agreement now, the Swiss agreement partially. So for some of those, they will either continue to apply or partially continue to apply. Others, the UK will have to continue negotiating and will hopefully get done in a reasonable amount of time. But the fact is you need to check one at a time whether the UK has successfully negotiated either a continuation of the EU deal or a new deal to replace the EU deal. But as a kind of default position, the UK will cease to be a party to anything that it signed while an EU member on trade.
Thanks, Dimitri. Let's turn to this issue of contracts and specifically Incoterms. Jonathan, the government's advice says to make sure you use the correct Incoterm. Which ones do you recommend?
Well, it's quite difficult to recommend an Incoterm without knowing more about where the relevant business is in the supply chain. I mean, from a supplier's point of view, generally speaking, EXW or X Works is regarded as most favourable to them because that makes your buyer responsible for transport from the supplier's premises, together with compliance with customs formalities and payment of any duties. For buyers, DDP or delivery duty paid is generally regarded as the most favourable to them because that's effectively the opposite of X Works. It makes the supplier responsible for delivery to the buyer's premises, and the supplier also has to ensure compliance with customs formalities and pay any duties. But there are a couple of important caveats here. If you export to the EU, you need to be able to show that the goods have actually left the country so that they can be zero rated for VAT in the UK. And one of the problems with EXW is that because your buyer is responsible for transport from your premises, you won't automatically get that evidence of export. Now, that's not to say you shouldn't use EXW, it's just to say that you need to ensure that the contract includes an obligation on the buyer to provide you with the necessary documentation. Because if you don't do that, you could find yourself being chased by HMRC for UK VAT. Now, that evidence of export will usually be what's called the goods departed message from the UK customs IT system, but it could also be the buyer's transport documents.
So what about DDP? Is there anything we need to watch out for there?
Well, DDP is something you'd probably want to avoid as an exporter anyway, because it's not very favourable to you. But after the end of the transition period, there's even more reason to do so. And that's because the requirement to deliver to your buyer's location may mean that you're expected to register to account for VAT in that EU country, which you obviously want to avoid if you can. If you import from the EU, you may well be keen to contract on DDP terms, but you may find that your EU suppliers are resistant to this because they won't want to have to register for VAT in the UK, and they may also be concerned about having to meet the extra cost of compliance with customs formalities and bear the risk of delays. So to sum up, Incoterms is something you need to think quite carefully about because Brexit changes the balance of risk in relation to issues like VAT, payment of duties, customs formalities, and so on. But I'm afraid it's hard to recommend a particular Incoterm without knowing more about where your business sits in relation to all those issues.
Well, a big thank you to Dimitri and to all of our Travers Smith panelists for joining me for this session, which I hope you found informative and helpful for the purposes of your ongoing Brexit planning. And thank you, all of you, and there are many people on the line, for joining. You'll find all of our contact details just below on the slide, and also links to some of the articles we've been talking about. And there's also a wealth of information on our website should you need further details on any of the issues we've been discussing. Thank you again for listening, and we hope you can join us for another session soon.